Hello everyone, welcome to the U.S. Immigration Hub. After President Donald Trump returned to the White House, the landscape of U.S. immigration policies has undergone significant shifts with the introduction of new executive orders. The USCIS I-130 family visa process is set to experience substantial changes, and these modifications are expected to create a more complex and challenging pathway for families seeking to reunite in the United States. In this video, we will delve into the key changes that have come into effect as of January 2025 for family-based immigration and I-130 applications. If you are interested in this topic, please be sure to watch the video until the end. And if you're enjoying this video, please hit the bell button, subscribe, and like it so you can get updates straight to your smartphone. Now let's get into the video and jump right into the topic. So what are the key USCIS changes to the I-130 process starting January 2025? Beginning January 2025, several transformative changes will be implemented in the I-130 process. These updates aim to streamline the system, enhance efficiency, and address some of the long-standing challenges faced by applicants. Let us explore these changes in detail. Number 1. Waiver of adjustment of status requirements. One of the most notable updates involves a waiver of specific requirements for individuals applying for adjustment of status. Effective January 22, 2025, USCIS will no longer require applicants to meet certain eligibility criteria traditionally associated with the adjustment of status process. This policy shift has the potential to simplify the pathway to lawful permanent resident status for a significant number of applicants. By removing these hurdles, USCIS aims to expedite case processing and alleviate some of the bureaucratic burden that applicants currently face. Number 2. Streamlined family reunification process. Another significant development is the introduction of new guidelines designed to streamline family-based immigration. While the precise details of these guidelines are yet to be fully disclosed, the overarching goal is clear: to make the family reunification process more efficient. This could mean faster processing times, clearer procedural steps, and potentially fewer delays for families waiting to be reunited. For petitioners and beneficiaries alike, this signals a hopeful shift toward a more accessible immigration system. Number 3. Updated visa availability and priority dates. The January 2025 Visa Bulletin reveals noteworthy changes in priority dates for family-sponsored categories. These dates determine visa availability and significantly impact when applicants can move forward in their immigration journey. For instance, the priority date for unmarried sons and daughters of U.S. citizens under the F1 category is now set at November 22, 2015, for most countries. Similarly, for spouses and children of lawful permanent residents in the F2A category, the new priority date is January 1, 2022. These updates reflect efforts to address backlog issues, though some categories, such as F2B, unmarried sons and daughters of permanent residents, continue to face longer wait times. Number 4. Adjustments to eligibility criteria. While the core eligibility requirements for filing Form I-130 remain consistent, there are some updates to be aware of. Applicants must still undergo inspection and either be admitted or paroled into the United States. Additionally, they must be physically present in the U.S. at the time of filing Form I-485, the application to adjust status. Importantly, an immigrant visa must be available both at the time of filing and when USCIS makes a final decision on the application. These criteria, although unchanged at their core, are now accompanied by the waivers mentioned earlier, which could provide much-needed flexibility for certain applicants. Number 5. Changes to family reunification parole process. Starting January 22, 2025, updates to the family reunification parole process will take effect. Although detailed information about these changes is currently limited, they are expected to influence how certain family members can enter the U.S. while awaiting visa processing. This could be particularly beneficial for families separated by long wait times or procedural delays, offering them an alternative pathway to reunification. Number 6. Implications for different family categories. The impact of these changes will vary depending on the specific family category of the applicant. Let us break this down to understand how different groups will be affected. For immediate relatives of U.S. citizens, including spouses, unmarried children under 21, and parents, visas remain immediately available. The introduction of waivers could further streamline their application process, reducing the time and complexity involved. On the other hand, family preference categories such as F1, F2A, and F2B will continue to be governed by priority dates. While some categories show forward movement in dates, others still face prolonged waiting periods. It is essential for applicants in these categories to stay informed about changes to the visa bulletin and plan their applications accordingly. Number 7. Navigating the changes, tips, and strategies. In light of these updates, there are several strategies that applicants can adopt to optimize their immigration journey. First and foremost, filing as early as possible remains a critical step. The earlier you submit your petition, the sooner your case enters the processing line, which is particularly important given the potential influx of applications following these changes. Staying informed is equally vital. Regularly monitoring the visa bulletin will help you track priority date movements and ensure you are prepared to act when your category becomes current. Additionally, organizing your documentation meticulously can save significant time and prevent unnecessary delays. This includes gathering proof of the familial relationship, financial evidence, and any supporting documents required for your specific case. For immediate relatives eligible for concurrent filing, combining Form I-130 with Form I-485 can expedite the process, allowing both petitions to be reviewed simultaneously. Finally, given the complexity of these changes, consulting an experienced immigration attorney or accredited representative can provide valuable guidance tailored to your unique circumstances. Number 8. Potential challenges and considerations. While these changes represent a positive step forward, it is important to acknowledge potential challenges. The implementation of new policies often comes with initial adjustments, and USCIS may face hurdles in adapting to these updates. This could lead to temporary processing delays or other administrative issues. Moreover, the easing of requirements may result in an increased volume of applications, potentially affecting processing times. Immigration policies are also subject to change, sometimes at short notice. Staying updated on the latest developments and being prepared to adapt your strategy is crucial. As always, relying on official USCIS sources and seeking professional advice can help you navigate these uncertainties effectively. Number 9. Real-world impact, a glimpse into the changes. To understand the practical implications of these updates, consider the experience of a recent applicant. In a report shared on an online immigration forum, an individual filed I-130 petitions for their parents on January 15, 2025. Within hours, they received confirmation receipts through the online filing system. This swift response highlights the efficiency of USCIS's updated systems, suggesting that the new policies are already making a tangible difference for applicants. Looking ahead, the future of family-based immigration and the changes to the USCIS I-130 family visa process reflect a broader commitment to enhancing the family reunification framework. By waiving certain requirements, updating priority dates, and streamlining procedural steps, these updates aim to create a more efficient and family-friendly immigration system. However, the journey remains complex, requiring applicants to remain vigilant, proactive, and well-prepared. Key takeaways include the importance of understanding the waiver provisions, staying informed about priority date movements, and seeking professional guidance when needed. By taking these steps, families can navigate the evolving immigration landscape with greater confidence and clarity. In conclusion, the updates to the USCIS I-130 family visa process mark a significant milestone in U.S. immigration policy. While these changes offer new opportunities and potential benefits for many families, they also come with challenges that require careful navigation. As you embark on or continue your immigration journey, remember to rely on accurate information, stay prepared, and seek assistance when necessary. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas EB1, EB2, EB3, EB4 and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.